Hello everyone and welcome to this Privacy Kitchen coffee break. I'm delighted to welcome Tim Bell from DataRep into the Privacy Kitchen. Morning Tim, how are you?
Good morning, Robert. Yes, very well, thank you. How are you?
Very good, thanks. I'm delighted to have you on. As we were chatting just before, you're incredibly busy at the moment with the effects of Brexit. One of the byproducts, the many gifts, is a higher visibility of this representative, what you termed the forgotten obligation. So this is a really, really timely interview. It's really great, a great Privacy Kitchen session. So I'm obviously the founder and CEO of Keepable, GDPR software as a service solution. It's a privacy framework for GDPR and UK PECA, and we also have a privacy policy pack. And we provide these Privacy Kitchen sessions as a free way for people dealing with GDPR and privacy generally in their organizations who often aren't privacy professionals to get really practical tips. So I'm delighted you're here today. Tim, would you do a quick intro?
Yes, absolutely. So I'm Tim Bell, founder and managing director of DataRep. We provide the EU representative service under GDPR and now also the UK representative service under UK GDPR, but we'll get on to that. I'm a qualified solicitor in England and Wales by training, and yes, excited to join you in the Privacy Kitchen. Thanks for the invite.
Absolutely, and so people can find out more about DataRep on the website, and we'll also be having delighted to have a guest blog from you. But on that, let's go straight in. There's a lot to talk about. An EU representative. Let's start with the EU representative. What is an EU representative?
Absolutely. So when GDPR became enforceable in May 2018, it was very much one of the quieter bits of GDPR, particularly when we were talking about it in Europe. And effectively, the representative is designed for companies which are outside of the EU and the European Economic Area, who are impacted by GDPR because of the extraterritorial effect. So those companies are required to appoint a representative which will act really as the privacy face of those companies within the EU. And they really are the point of contact. They're the ones who the data subjects or the data protection authorities within the EU would contact if they have any questions or if they wish to enforce any rights against the company which is processing their data from outside of the EU.
Absolutely. So it is really that sort of local contact point, isn't it, for the regulators and the data subjects? And so that sounds quite different to a DPO. Could you just sort of give us a bit of a flavor on some of the things where it's maybe similar to a DPO and some of the things where it's quite different?
Yes, absolutely. So the DPO role is very much an individual or a role which is very close to a company. They will be involved with their data processing in as much as they'll need to know the nitty-gritty detail of that company's data processing activities so that they can ensure that those activities are working in line with GDPR. So that company has a very close relationship with the company. They either they can be an internal appointment or they can be an external appointment. But even if it's external, they'll work very closely with that company to make sure that those data processing activities are in line with GDPR. The representative is necessarily outside of the company because when we act for a company which is outside of Europe, and we sit within Europe and effectively act, as you say, as their point of contact. So where the DPO role is very focused really on the processing, the representative is much more focused on the exercising of rights because they're the ones who will be the first point of contact for those individuals and authorities when they're looking to enforce or to exercise those rights.
That's a really interesting one. The DPO absolutely can be internal or external, but the representative, just by its nature, is external because you don't have an establishment in the EEA, so or in the UK we'll come to. So let's just say Europe for the moment, for until the end of the year. Let's just talk about Europe as the UK and the EEA. So it's when people don't have someone in Europe, and they need someone there for people to contact. So that's a very, very different thing. And the advisory bit, what about the advisory bit? Can you just say a bit more on the advisory between a DPO? Obviously, they can't be conflicted. Is there a similar sort of range of obligations and requirements on a representative?
So actually the interplay between the DPO and the representative is very interesting. So whereas the DPO, as you say, has an obligation to be independent and needs to have the ability to raise their concerns with the highest level of the company if they have any issues. whereas the representative is much more a contractually driven role. So the representative really follows the instructions of their clients, and they don't have that power. They don't need to have that power to be able to raise their concerns and issues. And actually, because of that, the European Data Protection Board and their guidance 03/2018 has confirmed that the DPO and the representative shouldn't be the same organisation because of that risk of a conflict of interest, because they may be asked to do things as representative, which would perhaps cause concern if they were also the DPO.
Yeah, that's their territoriality guidance, isn't it? On and it's
Absolutely.
interesting in that guidance they give lots of different examples of when GDPR does apply and when it doesn't apply, and every time pretty well they say, and therefore they need an EU representative, or and therefore they don't. So the representative very much in the EDPB's, the European Data Protection Board's front of mind all the way through that guidance.
Yes, absolutely, and it is really a key part of that extraterritorial effect of GDPR, and that's really why we came to set up. We realised that it was going to be a major part of GDPR for these non-EU companies, and that's what we've seen so far, really. I mean, certainly there has been a greater attention on the DPO role, and we've seen more enforcement on the DPO role at this stage. But the representative is really going to be something which grows in existence, and it is now actually starting to look into the into other jurisdictions as well.
So we're getting close to the UK part and the Brexit part. But let's just hold off on that a little bit longer. It's the anticipation can build. But so it is interesting. There's been so much in GDPR for people to get their heads around, really. I mean, a lot of GDPR was there before in the old Data Protection Directive. It's just the fines were a lot bigger and it's expanded it. So people are suddenly paying more than lip service to data protection law, and now they're realizing they have to be compliant on a business as usual role. And I think that what you just said there is very interesting. I think people look for the it's a risk-based law, so people will address the big things first. And one of the big things, obviously, is getting privacy policies and procedures and a system in place, and your privacy notices and cookie notices, all the very visible bits. And then the data protection officer, there's been some fines recently on that we were discussing, and we can come back to that. And I think now the EU representative is one of those ones that's next on the conveyor belt of how do we make sure we're compliant. And it's next on the conveyor belt of investors and auditors and everyone and regulators going, okay, so this is a highly visible way to check. But we'll come back to that bit in a little bit. I just wanted to ask for some examples of maybe from your clients or from the regulators about when do you need an EU representative under the EU GDPR?
Yeah, certainly. So I suppose at its most basic, it's companies which don't have an establishment in the EU. And establishment can be interpreted quite widely. It doesn't need to be an incorporated company or a registered branch. It can just be a few individuals working out of an office. It can be pretty loose.
Yeah.
But if you don't have an establishment and you're impacted by GDPR, therefore under Article 3.2 for companies outside of Europe instead of Article 3.1 for companies in Europe, then the basic rule is that you will need a representative. Now, there are a couple of exemptions. The first one is public authorities won't need a representative, and the assumption is there that it'll be possible to reach a public authority in some way or another. There's an exclusion for work outside of the realms of EU law, and that's a very small exemption, really. It covers things like national security and aspects like that. And then there's what has been, I wouldn't say necessarily misinterpreted, but there's been a difficulty interpreting what's called the occasional exemption.
Yeah.
And to fall into the occasional exemption for the representative, you need to be only processing European data, EU personal data on an occasional basis, and that data isn't likely to cause risk to the rights and freedoms of individuals or involve large quantities of what's deemed the special category data, so your medical, criminal convictions, religious, ethnicity, that type of thing. Now, as to what is occasional processing, there's obviously quite a lot of room for interpretation there. We tend to interpret it along the same rules as other parts of GDPR, that processing is occasional where it's a type of processing which isn't done regularly. So we would say that it isn't occasional processing of European data if you're only occasionally processing European data, but in a process which is a regular part of your business. So for example, an e-commerce site, if let's say a North American e-commerce site specializing in ice hockey. So most of their buyers are going to be in North America. That's where the interest is in that sport. But there's going to be some interest in Europe. And if they occasionally sell to Europe, then those companies might say, okay, we fall under the occasional exemption. But actually the processing activity is one which is regularly undertaken by them. It's their basic business model. So we would say that there's a good chance that that processing isn't deemed occasional, because even though it only rarely touches European data, it's a regular process for that organization.
There's interesting guidance on that, isn't there, in the well, actually in that territorial guidance, but also in Schrems 2 and following Schrems 2, everyone's talking about the Article 49 exemptions to be able to use things like consent or what have you, and they're all being, everyone's being told very clearly those are occasional. And as you say, if you've got something that's part of your business strategy, that's just certainly not an occasional thing. Even if it's not really regular periodicity, if it's a planned thing, then it's not an occasional thing.
Absolutely, and we take that view, and I think we'll see a bit more of a focus on the enforcement in that in the future, and hopefully a bit more clarification.
Yeah, for sure. Let's set out a couple of examples that the regulators gave us. I think we can use going forward as well in this conversation. So, like they gave an example of a South African hotel that obviously, it's a hotel in South Africa. It has no footprint anywhere in Europe, but it does have European visitors to the hotel, and it markets to those European visitors. And the guidance was, well, because, as you say, there is a regular part of their business to market in, to offer goods and services to the individuals in your Article 3.2 applies, and they need a representative. But that if that South African hotel was part of a bigger group and it had an office in, say, in London or Berlin, then that office in London, Berlin that would be marketing the hotel and organizing campaigns would be its establishment, and so they wouldn't need a representative in that situation. So I think that's an interesting one. We can come back to that sort of South African hotel. And your North American ice hockey website's a great one. So let's keep coming back to that one as well. So with that ice hockey website in North America, can you just take us through with their decision process as to do they need a representative or not in Europe again?
Absolutely. So the first step will be to establish whether GDPR applies to them. And so they'll be looking at Article 3. They'll be saying, okay, we don't have a location in the EU, so that's very easy. We don't fall under Article 3.1. But are we either selling or, well, providing, and selling is slightly misleading here because you don't need to be gaining money from it. You can be providing a free service. But if you're providing goods and services to the EU, whether for price or not, or if you are monitoring people in the EU, then GDPR will apply to you under Article 3.2. And it's worth noting that monitoring has a pretty wide definition to bring in a lot of aspects. And really, if you're processing data on someone, then the chances are you'll be able to draw conclusions about what they're doing. And therefore, monitoring is a very easy hurdle to get over, to be found. So there we go. If you've confirmed that you are GDPR, you're caught by GDPR, then that's your first step. Next step is, because you're under Article 3.2, the presumption would be that you need a representative. Then you check whether any of the establishment of the exclusions, beg your pardon, apply. So obviously, an ice hockey website won't be a public sector body. They won't be dealing with areas outside of the EU law. Then it comes down to the occasional exemption. And really, it's their one and only main business activity. They get orders and they fulfill them. So certainly it isn't an occasional activity for them, although they may only occasionally sell to Europeans. And so effectively, they fall into the situation where they will need a representative. And I mean, to be honest, the biggest part of it is, do you have a location in Europe, and are you selling to Europe? And those are the two easiest questions for most companies to establish their representative need.
Yeah, I agree. It's easy to overthink it. That's a really good rule of thumb. And then in terms of our South African hotel or the North American website, they've decided they need a representative. They're marketing, they're targeting, they're monitoring people in the EEA. Where does that representative need to be in the EEA?
Yes, absolutely. And this is a really key part. So when you're looking for a representative, it should be located, or it should have an establishment in the EU country where you have the largest number of data subjects. And apart from convenience, that makes a lot of sense. In order for that entity to be representative of an organization, it needs to be there on the spot for those individuals. And that was really confirmed. The basic wording of GDPR is that the representative should be in one of the countries where you have data subjects. So that gave a little more scope for room. Then the European Data Protection Board guidance that we talked about before has confirmed that the representative should be located in the country where the most data subjects are based. Now, it's not a fixed rule, but what I would say is that it's given as an example of good practice. And frankly, because of the privacy by default and privacy by design and default expectation under GDPR, it's, to my mind, certainly it's an expectation that good practice should be followed. People should be, if it's possible to follow good practice guidelines, then really in order to be compliant with privacy by design and default, then you should be following those guidelines. And Absolutely. So if you can find a representative which has an establishment in the country where you have the most data subjects, then that should be your primary point of contact.
Yeah, because they also be easily available, don't they? So that makes sense for them to be in that place. They speak the same language, same time zone, etc.
Absolutely, and the easily available point is also relevant because the guidelines say that individuals in other member states, so not the one where you've got the most people, but individuals in other member states should have easy access to that representative. And the way that we interpret that is that really it should be in, if not the country where those other data subjects are based, at least a country which is fairly proximate. If not a neighbouring country, then at least one that is quite close. So the example would be, let's say, again, talking about the North American ice hockey website. So most of their customers are within Ireland, so they look to place their representative in Ireland, and that makes perfect sense. But maybe they've got a really big contingent of fans in Bulgaria and Malta. And so for those Bulgarian and Maltese individuals, actually the Irish location of the representative isn't particularly useful for them at all. So having a representative which has establishments in many EU member states is certainly ensures that you have that greater level of compliance with those guidance.
Absolutely, and that's a nice segue. Now we can crack the nut that is Brexit. It's a really good segue into that. So in your example, so first off, Brexit, obviously there's been a transition period this year, so we're deemed to be part of the EEA still. But at the end of this year, so from 1st of January, we're no longer. Brexit transition period ends. We're out, and not going back in. And the UK GDPR comes into place. Basically, the EU GDPR just with the EU written out and the UK in. So people will have the UK GDPR and the EU GDPR to look at. And one of the things that is, I think, that's raised representatives into the consciousness right now as well, and with regulators, is Brexit. Has actually really pushed representatives up to the top. So perhaps that example you gave about the ice hockey website or the South African hotel, say, with people in, say, Ireland and Bulgaria, maybe they've got some people in the UK. Could you just talk us through how Brexit comes into that thought process now?
Yes, absolutely. And the real key is, as you've said, is the dividing of the EU jurisdiction into effectively two jurisdictions for the purpose of representative. And that's the easiest way to think about it, is we've taken the EU as a group of 28 countries, and now we've split them into 27 EU countries and the UK separately. So the rules are pretty much the same, as you say. All that the UK has done is put a line through where it says the EU and putting the UK in place. So the UK law, as will apply from the 1st of January or whenever the transition period should end, if extended beyond that, is yes, and gosh, let's not get into that particular conversation, but effectively any company which is providing goods or services into the UK and has no UK establishment will now need a UK representative. Now, for our ice hockey website in North America, that means that they not only do they not have a location within the EU, they now don't have a location within the UK either. So they'll need both a representative in the EU, and also, if they have any UK clients, customers, they will also need a UK representative in the UK. So it's effectively doubled up on this regulatory obligation, and created this second role for the UK representative. Now, the thing is, for the North American Ice Hockey Company, that's not necessarily too complicated because they've already had to deal with getting the EU representative in place. The issue is going to be for the European companies who have never had to deal with a representative before. They've got an EU establishment, but they don't have necessarily a UK establishment. And they've never heard about this representative because it's not been relevant to them. They've been talking about their DPO, they've been talking about the data protection impact assessments, but they've never needed a representative. So it's completely off their radar. And they're going to find suddenly, and very surprisingly, that they need this representative in the UK. And likewise, UK companies have been in exactly that same position. They have not needed to have an EU representative because up until the end of the Brexit transition, GDPR has deemed them to have an establishment within the EU. But suddenly, they're not going to have that establishment. And those UK companies who've been selling to France and to Germany and even to Ireland for years and years and years under very beneficial trading relationship, is suddenly not only going to have a whole load of extra red tape with selling to the EU, but they may need to have an EU representative as well. And that's really proving to be quite a surprise with a lot of companies, and has led to, and I think with fair reason, there's been a delay with people preparing for Brexit simply because there's been so many question marks around what's actually going to happen. But I think now that we are getting down to the line, and as of today's date, for anyone recording, we're around 2 weeks before the end of the transition period as currently envisaged. We still really don't have much of a clue whether we're going to get a deal or not. But regardless of that, the representative obligation will apply. And even if the UK doesn't get an adequacy decision, which also appears fairly unlikely at this stage, that won't affect the representative obligation, because even countries which do have adequacy decisions still need to appoint the representative.
So I think that's a really good point. So I think we need to separate out the UK representative part and needing a UK representative from, as you say, the trade negotiations. So what customs duties apply and this sort of thing, it's not the same as that. So whatever deal happens on that, it's not related. Whether there's an adequacy decision or not, which we hope there is, time's running out. I think it's unlikely now. As you say, we're 15th of December today, so but fingers crossed. But if one comes through, or if it doesn't come through, it doesn't affect the UK EU representative bit either, as you say. So it is something people need to look at. And there's 28 million countries in the EEA 30 and the UK, so the 25 million in the EEA 30 and about 3 million here. And that's a conservative estimate because it doesn't include all the smaller entities. So there's a lot of businesses that need to look at whether or not they need either a UK business looking, do we need a representative under the EU GDPR now, or an EU or EEA business going, do we now need one in the UK? And most of that, well, our largest trading partner is the EU. So there's a lot of companies in the UK will need one, and a lot of companies in Europe will need a UK one. As you say, probably not so much of a change for people outside the European sphere. But you did some interesting research. I loved it on Privacy Shield, looking at companies there. Can you just tell us that? Because there was a really amazing statistic there.
Yes, absolutely. And this kind of goes down to what we were saying, what you mentioned at the start around this big, the hidden obligation of GDPR. It's we did some research after the Schrems II ruling on Privacy Shield, and just as a quick recap for anyone coming in fresh, the Schrems II ruling decided that the Privacy Shield, which was a mechanism which allowed the transfer of EU personal data to the US, the courts found that that Privacy Shield mechanism didn't provide enough protection of that EU personal data, so they invalidated it. Now, Privacy Shield lists all of the companies which are participants on a website, in the US government-run website, and we went onto that site and we took a sample of those companies and did some research to check for visible evidence of GDPR compliance, looking at 3 aspects you can assess externally, which are the existence of the privacy notice, the extent to which they are seeking valid consent for cookies, and whether they've appointed a representative if they need one. And we found on the representative side of things that around, give or take, 2/3 of the companies didn't have an EU establishment. But of those companies which therefore should have had a representative, fewer than 8% had actually made that appointment. And that was obviously something of a shock for us. I would love to say it was a huge shock, but it was more of a moderate surprise, I think would be fair to say.
But it's crazy. I mean, part of going into Privacy Shield was that you looked at the European GDPR and looked at the obligations, and you were building out a compliance structure, a privacy framework, privacy governance to comply, so that the rights of the individuals are respected. And for less than 10%, for just less than 8% to have a representative in Europe is, or at least publish that they've got the representative in Europe is shockingly low.
It is, and I think a big part of the reason is, for a start, Privacy Shield, in their defence, I'll give a couple of mitigating factors for Privacy Shield. So it was prepared in a bit of a rush after Safe Harbour was ditched by the European Court of Justice in the same manner, and it was created at a time before GDPR was enforceable. So it was 2016, GDPR had been agreed, but wasn't yet being enforced. And so the representative obligation was even less a part of the conversation than it is now.
More varied, wasn't it? It was an even harder test.
It was, absolutely. And so I think for that reason it wasn't focused on at the time. But one of the things that was focused on by Privacy Shield was the privacy notice. And what we found in our research was that almost 100%, it was 95% or more of the companies had a privacy notice that was available, and there was a link from the Privacy Shield website to that document. So the privacy notice obligation was heavily adhered to. And I think the reason for that was simply that it was a requirement of the Privacy Shield sign-up process. Now, if you make that same obligation, if you make that sign-up requirement the same for the representative, I think we're going to see a lot more compliance. And I think that's really where Privacy Shield, or whatever replaces it, ultimately needs to take more of a driving position to make sure that these companies are going to be compliant with GDPR.
But we've come up to the half hour, and this has been a really fantastic run through. And if I could just recap, basically the EU representative under the EU GDPR, we're now going to have a UK representative under the UK GDPR. If you're in the UK, you don't need a UK representative. If you're in the EU, you don't need an EU representative. If you're outside either of those, check to see if you're covered by the relevant GDPR, and then check to see if any exemptions apply. And you very nicely took us through those very clearly. And then if they don't apply and it's covered, then you need a representative in either the UK or the EU or both. And one of the big things will be UK companies realizing they need an EU one, and EU ones realizing they need a UK one, because I don't think there's a 95% success rate in some industries of having even a privacy policy on the website. It's got a bit better, but being made to look at it, it makes people have one on there. So Tim, thank you so much. It's been really great.
No, thank you for having me, Robert. It's always good to have these conversations and spread a bit of the knowledge.
Perfect, thanks very much. And so everyone can reach Tim through the DataRep website. They can also reach me through the Keepable one as well. And obviously, we're both on LinkedIn and Twitter and what have you, and we're happy to help anybody. Thanks very much, everybody.
Thank you.